Good afternoon. My name is Paul DeBolt. I'm chair of the Venable Government Contracts Group in Washington, D.C. On behalf of Venable and BDO, I wanted to welcome you to the first of 4 upcoming webinars we'll be putting on relating to issues and challenges that government contractors face during the COVID-19 pandemic. Today's presentation is entitled A Contractor's Guide to Maximizing Recovery on Certified Claims and Requests for Equitable Adjustment during the COVID-19 pandemic. Joining me on today's panel are Aaron Reddick, a partner at BDO, who's the national leader for BDO's government contracts practice, and Emily Unash, who is one of my colleagues in the government contracts practice here at Venable. The three of us really appreciate you taking time out of your day to join us, and we hope that you all stay safe and well during this very difficult time in our nation's history. So if we go to the first slide, kind of to set the stage for today, it's just a slide on the CARES Act. I'm sure everybody knows by now that the CARES Act was signed by President Trump into law back on March 27th. The reason that it's kind of important as background to our discussion today is it does provide guidance on and considerations for how government personnel can assist government contractors due to the challenges posed by the pandemic. For example, Section 3610 of the CARES Act authorizes federal government agencies to reimburse at the minimum applicable contract billing rates, not to exceed 40 hours a week, of course, paid leave, sick leave, a contractor provides to keep its employees or subcontractors in a ready state, including to protect the life and safety of government and contractor personnel. And, that's going to run from January 31st, 2020 through September 30th, 2020. What we're going to do initially is we're going to, throughout the presentation, have some polling questions just to get a sense as to the challenges and things that everybody are facing. The first polling question we have is to rate your level of concern on the COVID-19 impact on your government contracts portfolio. And the three answers are significant, some, minimal impact. And we'll take about 30 seconds to fill that out, and then we'll see sort of what the current state of play is for you and your company. So if you just take a moment and go ahead and fill that out, great. I'll have all the responses in it. Another second or so. Right now, as it's coming in, it looks like companies it's had some impact on companies, about 59%. And significant is 26%. So let's go ahead and go to the poll results. Here's what we got. So it looks like overall it's had a significant impact on 25% of the people's companies who are on the phone. 13% it's had minimal impact, which is good, and some impacts about 61%. So I guess it's having some impact, but it doesn't appear that the impact is as significant in the government contracts community as it is in some of the other parts of the economy. Some of the other key documents that I wanted to talk about before we launch into the meat of the presentation, in addition to the CARES Act, there have been a lot of memoranda that have been issued by the various agencies regarding how they're going to handle contractors and contract issues during the COVID-19 pandemic. The first one that came out that I thought was noteworthy was from OMB. It was a memorandum to the heads of executive departments and agencies regarding managing the COVID managing federal contract performance issues associated with COVID-19. It was interesting in that it encouraged contracting officers to make a determination or look to see if their contracting partners could telework rather than having to be on a facility. And then if, because of the nature of the contract, a contractor's employees could not telework, then the government should be flexible on contract delivery and completion dates. One of the other things the memo set out was that to the extent issues arise that require a company to submit an REA, that those should be considered on a case-by-case basis, and whether work is continued or stopped should be considered on a case-by-case basis as well. The memo sets forth some of the clauses that we're going to talk about today that excuse performance delay or cover situations where a contracting officer directs changes in performance. I think what's also important for our discussion today is that when reviewing REAs, the memo instructs contracting officers to take into account whether the required costs would be allowable, allocable, and reasonable to protect the health and safety of contract employees. So as you go through this process, documenting the issues that have arisen, documenting your costs are going to be very, very important. I think the other good thing that came out of this is that there was an instruction that if you seek an equitable adjustment or you rely on an excusable delay provision, it shouldn't negatively impact your past performance rating, which is, very important. On April 8th, there was a class deviation issued to the Federal Acquisition Regulation FAR Part 31 and DFAR Part 231 that immediately authorized contracting officers to implement the Section 3610 regarding the use of sick leave and vacation to keep the workforce ready. This one gave a little bit more guidance in that it reminded contracting officers that they had to be good stewards of taxpayer funds while supporting the resiliency of contractors. There's a lot in the memo, and you could probably spend 30 minutes talking about the memo and all of its details, but I think the things that are important to take away from the memo are that if you do seek reimbursement for these paid leave costs, you can't double dip with other COVID-19 relief. So you're going to have a strategy as to what funds you're using and how you account for them, given all the funds that are available. And then you're going to have to show that the cost of paid leave were incurred as a consequence of this national emergency and would not have been incurred as a normal course of business. And then the last one, there's another memo that came out on the 9th that I don't have on the slide that talks about implementing guidance. It's actually entitled, it's April 9th. It's from the Undersecretary of Defense. The subject is Implementation Guide for Section 3610 of the Coronavirus Aid, Relief to Economic Security. And the focus of this memo is to ensure traceability, that the contract and supporting documentation clearly identify the costs that have been reimbursed to contractors. It highlights that the way that you're going to recover costs under 3610 is going to depend on the type of contracts that you have. If you have a firm fixed price contract, the adjustment's going to be made through an REA. If you have a cost reimbursement contract, the recommendation is it's treated as a ODC for COVID-19. And if you have a time and materials contract, the memo recommends the creation of a new contract line item number that you could bill against. And of course, all of this is going to be subject to the availability of funds.
Paul, if I could add on there a little bit, I think our survey results sort of underscored what most of us feel, which is, it's a good time to be a government contractor compared to a lot of other industries that are hit pretty hard to this. We've got money flowing, obviously, and we've got accelerated payments. We've got some increases to the acquisition thresholds. The government is using things in its arsenal, as it often does, through the government contractor community to prop up the economy a bit and influence its socioeconomic agenda as well. But one thing, at least I felt, I don't know if I'm alone in this, is there's a little bit of a change in rhetoric, I thought, between, some of the CARES Act and some of the initial OMB guidance, which talks about all the flexibility that's going to be afforded and, and the ability to get recovery for all the costs that are being incurred here. And then not that it changed entirely, but some of the more recent DPC, frequently asked questions and guidance, changes a little bit to some of the language you referenced yourself, Paul, which was, 3610 doesn't compel reimbursement of paid leave. You do have that good stewardship that you have to exercise. You do need to look for other sources of funding. So, I read that and put it all together and feel like, okay, this is telling us that in the details, how is this going to really work out? And there is going to be that scrutiny and that concern when it comes to filing the REAs and claims that we know are coming and initiating now. And so that's, part of the reason we're obviously talking about this today.
Yeah, and I think you make a good point, Aaron, in that, at the outset of the pandemic, the government wants to do as much as they can to help the economy, and, certainly government contractors are one way to do that. But, having been through any number of crises with the hurricanes and things like that, people kind of forget, what was the impetus for the money and what they were asking you to do with the money. And then the auditors come in with perfect 20/20 hindsight and start to question how and why you spent the money and whether your paperwork is sufficient or not. So as you're going through this process and getting the money you're entitled to, you need to ensure that at the back end, you're going to have the documentation to support why you made the decisions that you did. The next slide we're going to talk about and these are some of the clauses that frequently come up in the memos that have been guidance that have been issued by the federal government as potential areas of recovery under the CARES Act. I mean, of course, the first one is the changes clause, 52-243-1 or 52-243-2. We'll talk about this in a little bit more detail, but this is where you're directed to perform additional work that's either within the scope of the contract or out of the scope of the contract. There's a similar changes provision under 52-212-4 for commercial items. That's 52-212-4C. You have suspension of work provisions under 52-242-14 that applies to construction contracts. You have 52-242-17, government delay of work, which applies to fixed price supply contracts, and it's optional for some service contracts. You have usable delays under 52-249-14, and you have stop work orders under 52-242-15. So, I mean, it's important to know, as these issues arise, which of these clauses are in your contract and which of the clauses are going to put you in the best position to maximize your recovery. Now, one of the things I did want to highlight before I move on to the next slide is that while courts and boards have over the years viewed past epidemics and quarantine restrictions as excusable delays, the existence of an epidemic or imposition of a quarantine restriction in and of itself doesn't mean your performance is going to be excused in the absence of showing some causation and a lack of fault or negligence by the contractor. There are a number of cases throughout the 60s and 70s where people have claimed that there were flu epidemics and things like that, and because they couldn't show the causal connection, the boards didn't provide them the requested cost that they had thought they had incurred. If you're going to recover under an excusable delay clause, you're going to have to show, so you're going to need to document that any asserted delay in performance was in fact caused by the pandemic, and that the delay was beyond the control and without the fault or negligence of your company. So if you are able to show that, and document it contemporaneously with the issues that are arising under a contract, you're going to put yourself in a better position going forward. Now, even though the government is emphasizing some of these clauses as particularly relevant avenues of recovery or potential avenues of recovery under the contracts, you really need to remember there are other avenues of recovery too, because not everything might fit into one of those clauses that we talked about. So on slide 5, we outlined some of the other clauses that may be available: suspension due to a bid protest, revision of technical data, differing site conditions, failure to include the Service Contract Act. I think the takeaway for sort of this portion of the discussion with the clauses that are in your contract is the people that are on the front line every day dealing with their government customer need to know what they're required to do in the statement of work or the performance work statement, so that to the extent something changes, they can identify the change, get it to the appropriate level of management so you can figure out how to set up the appropriate controls to make sure you're capturing the cost or the data to support the change should you decide to file an REA or a claim. I think probably now more than ever that with the amount of money that's flowing into the system, with the amount of scrutiny that's going to occur after the money is spent, that adhering to sort of the fundamental blocking and tackling of government contracts is going to be very, very important. The next slide talks a little bit about the difference between a claim and REA. It's relatively straightforward. The claim's obviously more formal. It has a certification requirement. You have to request a CO decision. You need to state a sum certain, which we'll talk about in some detail. You're not going to get the cost associated with the claim. You do get interest when the CO receives the claim, and you can appeal any decision by the CO to either one of the boards of contract appeals or the Court of Federal Claims. Now, with regard to a claim, when you submit it, the contracting officer is on the clock. If it's a claim of $100,000 or less, the CO has to issue a decision within 60 days of the request. If it's over $100,000, they should issue a notice within 60 days, issue a decision within 60 days, or at least within 60 days tell you when the decision is going to be issued, so you can track that. REA is a certification requirement in DOD. It's basically a request to negotiate a resolution of an issue that arose under the contract. You're going to have to come up with a theme or a theory or a discussion or a narrative to say why you're owed the money, and then you're going to have to show the pricing logic, how you got to the dollars that you're claiming. The one benefit to an REA is you can recover the cost of preparation of an REA. So if you use in-house personnel or outside counsel, you can fold that into the REA. The downside is it doesn't trigger interest. And if the CO issues a decision on it, it's not going to be appealable. It's not going to be a final decision. So it may require you to take another step in the process in order to get the thing teed up for an appeal. Aaron, do you have any other thoughts on claims versus REAs?
Not specifically, but you did make me think of one thing, just speaking about the differences with DOD, and it probably didn't fall under the common, or it's not as common theory of recovery, but sometimes in the DOD space for our defense contractors, what we run into, and it may be on theme here, is that DFARS clause 252, 237, 7023, where it's the mission critical functions, and you have if in a crisis the CO requires you to implement your crisis plan basically for whatever portion of the contract is critical, you've got a separate sort of changes, REA claim type of function within that clause too. So I don't see that as much, but it is one of the differences in the DoD world and another area of potential recovery here.
Right. Next thing we're going to do, we have another polling question. And this polling question is, how responsive has your government customer been to schedule or cost impacts as a result of COVID-19? And the answers are very, somewhat, unresponsive, or does not apply. So why don't we go ahead and take 30 seconds and see what people are facing out in the field.
This is our trick to make sure everybody's engaged, right, Paul?
Yeah. So our preview. Everybody a second. This will be interesting when we get the final results. I mean, right now it's 32% of the responses say that it does not apply. 3% said unresponsive, which is good. That government personnel are taking this seriously and making themselves available to help. About 46% said are saying somewhat, and 19% say very. So we'll just give it another second or two, and then we'll go ahead and post the results. All right, let me go ahead and see how the results came out. There we go. So, oh, sorry about that. There we go. So how responsive has the government customer been to schedule or cost impacts? 19% said very, 45% said somewhat, less than 3% said unresponsive, which is good. And it's good that a vast majority of people have said that it doesn't even apply, so that's good.
Yeah, I'm a little bit.
Right,
that's good. Anecdotally, I'll just add. I mean, talking with lots of contractors over the past few weeks. I mean, it does seem to echo what we just the results displayed, at least for the variant somewhat. But I've felt from helping contractors and just what we've heard has been happening from their CFOs and such is it's really been an individual case by case basis. I mean, it's been a lot, I think, of some sort of receptiveness to some kind of adjustments and payments and recovery, but the formatting has been different in some cases. Some of the rigor has been, think about the language around profit that we'll talk about a little bit later, where you were not really supposed to apply profit or recover profit, yet you can bill up to 40 hours for paid leave at your full rates, which would include profit. So how do you back that out? That's been different. I've also heard the intelligence community has been a little bit more challenging for some, but and by and large, it's been, from what we've been seeing, they've been getting through. It's just a matter of how and the nuances, as always, with the particular circumstances.
Yeah, I mean, I think your point emphasized, Aaron, that a lot of this is going to be based on the relationships you have with your government customer. I mean, I know a lot of clients have very strong relationships, and there's more of a partnering view of that relationship, and I think those are working. But where the relationship isn't as close, I do think that it can be a little bit more challenging to get the level of responsiveness that you would think you would get during this time. The next slide just goes in a little bit more detail on requests for an equitable adjustment under 52-243-1, changes fixed price. I mean, what this does is authorize the contracting officer to make unilateral changes within the general scope of the contract. It's drawings, designs, specifications, method of shipment or packing, place of delivery. It gives you a right to request for an equitable adjustment. I think the thing that's important is the timing, that once you identify that, once you've been directed to do something under this clause, that you get your team together and make sure that you can hit the gate to get things within 30 days, or if it looks like you're not going to be able to hit the gate, to at least to have a conversation with your government customer to let them know and agree that, the fact that you're outside that 30-day window isn't going to be used against you later. As I mentioned before, an REA is a matter of contract administration. There's really shouldn't be a whole lot of dispute over what's entitled, what you're entitled to monetarily, and then the other points we covered on the previous slide. Okay, the next thing we're going to talk about is our claims, and I'm going to turn this portion of the discussion over to my colleague, Emily Yunesh.
Thank you, Paul, and good afternoon, everyone. For those of you in DC, thanks for joining us on this rainy, cloudy afternoon. As Paul mentioned, I'm going to speak a little more on claims and maybe do a bit of a deeper dive on that. I think, a lot of folks, probably both contractors and on the government side, sort of hope that we never have to get to the claim process, that we can all agree with a request for equitable adjustment and, the process ends there. But a claim is defined by the FAR as a written demand or written assertion by one of the contracting parties seeking as a matter of right the payment of money in a sum certain, the adjustment or interpretation of contract terms or other relief arising under or relating to a contract. So this is one of those definitions that it can seem fairly straightforward on its face, but the deeper you dive into it, the more complex it gets. And a lot of folks get really caught up with some of the key parts of this definition that may end up resulting in them not recovering. So a couple things. What is not a claim? Routine request for payment. So sending in an invoice to the government, even if you include something on it, saying this is a claim by us, an invoice, a voucher, that is not going to constitute a claim. There are numerous other boxes that you're going to need to check to meet the formality requirements for submitting a claim. A request for equitable adjustments. This is kind of an interesting one because a request for equitable adjustment can be converted into a certified claim or a claim in general. And it's kind of an interesting process as to when you might decide to do that. As Paul mentioned, requests for equitable adjustment can be useful in terms of recovering fees that you incurred in drafting the request. On the flip side, submitting a claim, you cannot claim any of your costs in drafting the claim. So there's a bit of perhaps strategy there in terms of timing and how you're going to come up with the factual basis for your request for equitable adjustment or claim. But a request for equitable adjustment in and of itself does not constitute a claim. So moving to the next slide here, I think I'm on 13. Who can be a claimant? So it's important to note that claims are governed under the Contract Disputes Act, and normally only parties to that contract, so that would be the prime contractor and the government, can be a party to a claim. So that means that the boards of contract appeals and the court are not going to hear a CDA claim by a subcontractor, a surety, anyone who's not the prime contractor or the government, one of the parties to the contract itself. You're not going to find jurisdiction under the CDA for that claim. The Court of Federal Claims does have some jurisdiction under the Tucker Act, but that's really a different conversation. And in addition, there are some situations where a prime contractor can sponsor a subcontractor's claim, and that would be, the terms of that would be governed by your subcontract. So digging into kind of the nuts and bolts of a claim, what does your claim have to include? And this starts to kind of break down that definition that we went over a couple slides ago. So the claim itself, it must be in writing, so it has to be a demand or an assertion that's in writing, and it has to seek as a matter of right the payment of money in a sum certain. That's sum certain is a legal term. I think Paul is going to get into that a little later on in the presentation. The claim must also seek adjustment or interpretation of the contract terms or other relief arising under the contract itself. So this is also key. At the end of the day, a claim is asking the board or the court to interpret your contract. So any claim that you have, it needs to be fundamentally based in your contract. Another key point is that a claim must be submitted to the contracting officer for a final decision. And this is a jurisdictional requirement. The claim must be submitted to the contracting officer. And the claim should also include an explicit request for the contracting officer to issue a final decision. And then finally, a claim, if it's over $100,000, a claim is required to be certified. And essentially what that means is, and in the best practice, is that you actually apply the exact language from the FAR, which states that you're submitting the claim in good faith and that there's nothing fraudulent. After submission of your claim. So it's important to note that after you've submitted a claim, before and after, obviously a lot might be going on. You might be struggling for funds. You might be having some sort of, you probably are having some sort of dispute with your government customer. But it's very important to note that you, as a contractor, still have a continuing duty to perform under that contract. So submitting a claim does not give you a right to simply stop performance. And in fact, if you do so, you put yourself at risk for being terminated for default, which can be a giant red flag and, potentially a death knell for a contractor if that termination for default is upheld. So in general, there are some exceptions here, but a best practice is that you should continue to perform. You can perform under protest, and then you could seek some sort of declaratory judgment, or you can seek your costs at a later time. All right, so now we're going to get into the timing of a claim. So when do you have to submit your claim by under the Contract Disputes Act? So the statute of limitations and this goes for both contractors as well as government claims, the statute of limitations is 6 years, and that is 6 years from the date of accrual. So the key question here, obviously, and what gets a lot of folks into trouble is, well, what is accrual? What does that mean? And the FAR actually defines accrual as meaning the date when all events that fix the alleged liability of either the government or the contractor and permit assertion of the claim were known or should have been known. So again, part of the definition is that for liability to be fixed, you must have incurred some sort of injury, but you need not have incurred monetary damages. And again, as to the last point, the courts, when they look at when has a claim accrued, so when did all of the facts underlying this claim become known such that your claim has accrued, the court's going to look at that from an objective perspective. So they're going to say what was reasonably knowable at the time. They're not going to look at what a party subjectively understood. And now I will turn it back to Paul to talk about what constitutes a sum certain.
Thanks, Emily. As Emily discussed, the claim states you have to include a sum certain in your claim. And a claim states a sum certain if the government can determine the amount of the claim using some simple mathematical formula. If they have to use a regression analysis or calculus or something else, that's not a simple mathematical formula. What I think the best practice is, and maybe want to get Aaron and Emily's view, is, to just put in what your specific demand of payment is going to be. I mean, you can amend your claim later, but at least initially you want to put what the specific amount that you're demanding. Now, you can base a claim on estimates if you identify what portion of the claim relies on estimates and explain how you arrived at those estimates using actual cost data. But you really want to be careful during that estimating process because you don't want to walk into a claim for fraud or misrepresentation. And remember, one of the many arrows the government has in its quiver is the Civil False Claims Act. And in order to be charged under that act, you don't really have to have specific intent to defraud. The standard is actually relatively low. It's reckless disregard for the truth of the matter asserted, which is probably closer to gross negligence. But unfortunately, based on the cases that I've had over the years, when you get an assistant U.S. attorney or an IG or somebody from DOJ civil fraud, they really put the screws down to about negligence. So if they think there was a 51% chance you made a mistake, then they could come after you. I mean, it's to me, the idea that you would put in a some certain actually seems straightforward, right? The government has a right to know what the amount that you're claiming is, but surprisingly, this is still an area that gives some contractors difficulty. There was a case that came out in February of this year called High Tech Laundrette LLC. It's an ASBCA number 62259, and and it wasn't a big claim. It was for $150,000, but the ASBCA dismissed it for lack of jurisdiction because the contractor requested a qualified amount of approximately $150,000. There's another case called Odyssey International. It has ASBCA number 62062, and the board dismissed a claim there for consequential damages in the amount of at least $15 million. And what was noteworthy in the opinion was that the board talked about the fact that qualifications of numerical amounts such as approximately, no less than, well over, at least, any of those types of qualifiers, actually fail to state a some certain. So it's just important to know that if you're going to go through the process of, pursuing a claim, putting together a claim, you really want to spend some time on the math to make sure that you do have a defined amount that you're asking for that can be supported by the records that you have under your contract. Aaron, I was going to turn it over to you and let you talk a little bit about the effect of a change order.
Yep, thanks, Paul. You guys have set a high bar here. No. Go ahead, Emily.
Aaron, I was going to suggest that we might, it looks like we have several questions. I don't know if you might want to address any of the questions from the audience as you get started here.
Sure. It looks like a lot of them look like they're marked answered. I see somebody asking me to repeat the DFARS crisis clause. That was 252, 237, 7023. I don't think I'm going to be able to nail the name off the top of my head, but it's something like continuation of mission essential services. But anyway, I do know the number at least off the top of my head. And actually, before we jump into the rest of this too, I mean, Paul and Emily, please weigh in here. I think you have to have the REA and claim differences and considerations in your mind as you navigate the COVID pandemic. But I think what most of what we'll be dealing with here and what will be advantageous to approach it as, it is the REA world, right? And you want to have that relationship with your contracting officer or prime and try to get, your treatment of certain costs and the recovery of those kind of hashed out up front. And while you don't necessarily get interest in the clock running under the REA, you do get your prep costs like we talked about recovered, which is helpful. And it's just an overall much less adversarial process generally. And then you always have the ability to convert it into a claim, later. And I'm sure that will happen in some of these cases in the future, but generally trying to avoid that. Paul, Emily, you guys agree with that?
Yeah, I totally agree with that. I mean, I do think that REA is a less adversarial approach. I think that, it's you're going to have to gauge your relationship with the customer and how strongly they feel about the issue. I think before you submit the REA, there's probably some benefit to having a discussion with them to let them know that it's coming over and what your concerns are. But, there are some clients that the relationship is so bad that it's not even worth wasting the time to file an REA because you're going to file it. It's going to sit there forever. and then you're finally going to get a decision, and you're going to be right back to square one, filing a claim. So sometimes if you have a difficult relationship, it's just better to start with a claim and put the government on the clock. Make them make a decision, and so you can get to the appropriate forum and protect your rights.
Yep, exactly. Okay, well, yeah. So the effect of a change order. I mean, so we're like we've been talking about. These can be a combination of either a formal change order from the contracting officer or the customer, or we can be talking about constructive changes and. When we've got to put the government on notice that a change occurred. But the effect is either more time. Well, I shouldn't say more. It can be additive or deductive. So we can be talking about less or more, and we're generally talking about time or money here. So or both. So if we are talking about time only, and there's a no-cost extension that's being requested, that's not unimportant, but doesn't have the quantitative aspects of things. If you're talking about dollars, then that gets into a lot of what we'll be discussing, for the duration of the presentation, which is the best way to approach that, the pitfalls, the ways to streamline the process. But if you're deleting work or there is a reductive change, then we can be talking about less time in dollars. The change, whether one or multiple, will be covering the total impact to the contract of the change, not just specific aspects of it. So it'll be the totality of the change. And I think one thing to be cognizant of, which is really at the top of the slide, is the limitation of cost, limitations of fund clauses, right? So, and that's referenced throughout some of the guidance that's been included around COVID-19 impacts. And so, this is, of course, you have to be cognizant of the specific change of whether it's paid leave for the ready state or idle facilities, what have you, that stemmed from the COVID pandemic and is the change in mind. But you also have to have your eye on the many intricacies and other impacts that COVID-19 has had on other than the specific contract, because in the instance of, a cost reimbursable contract, let's say, where you have, your indirect rates that are also impacted by changes across the board. Maybe you have a commercial practice as well that has fluctuated and has impacted your rates depending on how they're structured, or other circumstances where the rates change outside of the specific contract change that you deem a change, like we're talking about. That can also have an impact on whether the funding is available or whether the cost that you intend to recover will exceed the cost estimates that you provided. And so that's something that you need to be on top of and be speaking with your contracting officer about in order to avoid, disputes later on in the phases. So pricing of change orders, we're going to get into that. For the most part, you need to assert your right to an adjustment within 30 days of the change. There are specific instances where you will have this change order accounting clause, which will demand certain things of how you account for the impacted change and be able to present that proof, that evidence to your customer. Many contracts won't have that, and we'll talk a little bit more about that. But what probably is most impactful here is that for other than the cost reimbursable contractors, when you have a change, it effectively turns your contract into a cost plus contract. And so you to price a change to the extent there is additive or deletive cost, the cost principles are incorporated. And so you are accounting for costs in a different way than perhaps your books and records are set up to do, and perhaps different than what you've had to do before. And so you're, for the cost reimbursable contractors out there, perhaps run of the mill or business as usual, but for others, it is a different level of rigor that you need to be able to account for and prove your damages, so to speak.
Yeah, Aaron, I also wanted to point out that, as these change orders arise, you're going to have changes that are directed by the contracting officer, but you can also have constructive changes. And I think sometimes, if the contracting officer directs you to do something, that's pretty straightforward. But there are situations where a contractor performs work beyond the contract's requirement without a formal order under the normal changes provision because of either an informal order from the government or, the COTAR or somebody like that, or through some government fault. And, in those cases, you're still going to have to identify the change, give the government notice, and typically, they're going to want it in 30 days, but it's a little bit softer standard, because if the government can't show that they were prejudiced by your failure to give a notice of a constructive change within 30 days, then you can probably go forward. But, you just can't look on your contract all the time and think, okay, I'm just going to focus on the formal changes. There are things that arise during contract performance that could be a change as well. And, this gets back to the basics of making sure the people that are managing the contract on a day-to-day basis actually know what the contract requires. Sorry.
Right. Very, very important. Thank you, Paul. I mean, and really for the many of the folks on the call here that are impacted by COVID, like we've been talking about, I mean, this is a multifaceted impact, right? It's generally, at least kind of a big deal here, and it affects a lot of different things. And so that's why, these constructive changes are particularly important to highlight, because, there's a lot of different areas where the business can be affected and directly or indirectly have an impact on the contracts in question here, in which case that, 30-day notification requirement is triggered. And like Paul said, I mean, I've been in several circumstances where that 30-day notification requirement is soft, and there's no real damage or prejudice against that, but it's still, I think, something we would all advise to try to meet if you otherwise can. So in terms of, we talked about the change order accounting procedures for a second. You may have this clause in your contract. It's really a clause that should be inserted if there's a lot of technical complexity to the contract, and such that you might expect, or the customer might expect, several change orders to occur throughout the life of the contract. And what this will require for any changes over $100,000 is basically the best practices for accounting for changes, which our cost reimbursable contractors would be, typically doing anyway. And so that is setting up your separate job codes, your classification or separate accounting for different cost elements in order to be able to prove that nexus to the particular change that occurred and the costs accumulated directly from that change. And so it talks about the direct costs that are normally severable and accountable, the non-recurring costs, the distinct work that are caused by the change order, any recurring work that's related to the change order. And so it's just an extra level requirements that the CO can demand on a contractor to the extent this clause is included in your contract. Something to be cognizant of as you attempt to quantify impacts, whether you're doing something to protect yourself or whether you're doing something because you have to, and the contracting officer may require that level of diligence to consider recovery. Just two different bars there. So just overall importance of REA and claim pricing. I'm probably a little bit biased because I'm the quantitative guy here, but I think we would probably all agree it's quite important. And usually at the end of the day, it's about the money. Sometimes it's about the time, but often about the money. So, claim pricing, when you throw it over the fence here and you've completed your REA or your claim, the pricing side, the quantum is oftentimes, while it might be done last, and we always advise contractors to get out in front of this and be proactive early and build that up. Other than last, it still sometimes is done last, but reviewed first by the receiving party, right? How much money are we talking about? And then they may spend quite a bit more time determining how to react to the claim based on the quantum. And so they may ignore, and Paul and Emily, you can weigh in here, ignore entitlement or put it aside for a time and really defend the claim with respect to quantum, whether they throw it back at you because you haven't supported your claims or you've used estimates or you don't have the documentation or you haven't followed the change order accounting procedures, what have you. We'd like to push back on that first and foremost. The pricing effort usually does require a coordinated effort across different business processes or different departments within the contractor. So it's not usually a small effort. And so it does take time, and again, is obviously a very important part of your claim. So something you want to get right, not only to get your money, but also to speed the process, because like I said, it's something they love to do, to throw back your claim if it's inadequate in some way.
Yeah, I think that's true. I think there's a lot of. Go ahead. I'm sorry, Aaron.
No, I mean, and Paul, you touched on this already. I mean, in addition to just speeding the recovery and getting every dollar you can, of course, there are risks of overstating your claim or not supporting it in some way. And you hit on the biggest one, right, with the Civil False Claims Act. I always think of the Daewoo case, and not only not winning on its merits, but actually being held liable for what you otherwise claimed against the government instead, because it's a fraudulent claim. But in addition to that, defective pricing and potentially disapproval of your estimating system or other business systems if it's so egregious that other parties get involved and get wind of what a poorly supported REA or claim you have.
Yeah, I mean, I do think that, in my experience, that a lot of the government counsel spend a significant time on, cutting down your damages, because I think they want to put you in a position that, even if you succeed on entitlement, the legal theory, that you're not going to get much more than a Pyrrhic victory. And, the government, the people that work in the government, they work very hard, but they're sunk cost. It's their salary. But if you're a company and you have to hire outside counsel to pursue a claim, I mean, that's eating into profit. And and if the return on investment isn't going to be sufficient to pursue a claim, or if they can convince you that it's not going to be sufficient to pursue a claim, then that's a success for them. But it's just something you really need to think through. How important is the claim to the company? How much are you willing to spend to try to get it resolved? And getting a really good assessment as to what the relative strengths and merits of your claim is. I think a lot of times within companies, there's a group think that develops that something's stronger than what it is, and sometimes these things take on a life of their own. And if you can avoid that, you certainly want to do that.
Absolutely.
I think that Emily was
okay.
I think. Go ahead.
Yep.
Yeah, I think you're right. Emily's up.
I'm going to talk a little bit about some recent decisions by the boards of contract appeals where they denied a claim. So talk a little bit about what went wrong. But before I do that, I want to pause. And for those of you who are seeking CLE accreditation today, the code word is claims. So again, if you'd like to seek CLE credit for this presentation, the code word is claims. Now, moving back into the presentation. So a few recent cases, and these are actually, all very recent cases within just the past couple months, where the boards of contract appeals considered claims submitted by contractors and denied them. And I just want to go into a little detail on what went wrong for these contractors. So the first case I'm going to talk about, this is the Sang Cash case. And this was a case, it was brought pro se, so no attorney, by the contractor. And it is an interesting case because the contractor had originally appealed its default termination, and the board, the Armed Services Board of Contract Appeals, upheld that default termination. So after that was over, the contractor came back with a new claim, and that was a claim for additional costs that it had incurred during contract performance. And the contractor was, I believe, in Afghanistan and wasn't entirely sure of the process for submitting a claim. So they submitted what they called a claim. It was a letter to the military base there, and then later they forwarded that claim letter to the Armed Services Board of Contract Appeals. So the board took a look at this case, it was for a relatively small dollar value, under $100,000, and actually determined that the board did not have jurisdiction to hear the case. And the reason why was that the contractor had failed to submit a claim to the contracting officer for a final decision. So back up a little bit, I said, well, the contractor had submitted a letter to the military base, but in that letter, they'd failed to set forth any amount of damages. They'd really just asserted some sort of right to recover for additional costs, but they hadn't actually, as Paul had gone into earlier, they hadn't asserted a sum certain. And it was only after they filed their claim with the Armed Services Board of Contract Appeals that they actually did a detailed itemization of what they considered to be their damages. The board looked at that and said, well, you never actually submitted this claim to a contracting officer for a final determination, and therefore the board did not have jurisdiction to hear the appeal, and it had to go back to the start, and the board helpfully gave the contractor some additional information on how long they had to submit their claim to the contracting officer and sort of what to do since they weren't represented by counsel. The second case is NVS Technologies. This is a really interesting case because the contractor there sought to recover on two theories that have, I would say, you see with some regularity now. So the first was a bad faith theory. The contractor claimed that the Department of Homeland Security had terminated their contract for convenience in bad faith. And as kind of an alternative to that, they made a claim for the breach of the duty of good faith and fair dealing. One of the things that's interesting about this case is, you know, a lot of folks tend to think of those two legal theories as the same, but they're actually quite different, mainly in terms of the burden of proof that you have to establish as a contractor. So the contractor obviously bears the burden on either of these types of claims, but when it comes to alleging bad faith by a government official, the burden is extremely high. The government is, or all government officials are presumed to have acted in good faith in discharging their duties. And to overcome that, the boards and the court have held that the contractor needs to demonstrate well-nigh irrefragable proof that the government has acted in bad faith. In contrast to that, the implied duty of good faith and fair dealing is a implied duty in any contract, and it is a duty that arises under the same terms that are in your contract. So you still need to tie it to a term within your contract. But in the case of NVS Technologies, neither one of these claims turned out to be successful for them. One of the issues they had was the funding ceiling on their contract. The Department of Homeland Security had determined that the contractor just went way, way over budget. And in the decision, the Civilian Board of Contract Appeals really kind of took the contractor to task. It's not the best decision for them and may have been a bit embarrassing. So the contractor was claiming somewhere along the lines of, $280 million in lost profits. And the board pointed out, well, the ceiling on your contract was only $30 million. And they had failed to establish, either that the government had acted in bad faith or that they had violated that implied duty of good faith and fair dealing. So the last case I want to go over, recent case that was denied, was Korea Engineering. So this is an interesting one where the contractor was leasing certain property to the government in South Korea. And as part of the contract, the contractor was required to take back, so to go in and take back that leased equipment when they were done with it, I think within 30 days or so. And unfortunately for the contractor, during that time period, there were a number of protests that erupted in South Korea that blocked the contractor's ability to go in and collect their equipment. And this increased the cost to the contractor fairly substantially. They ended up bringing a claim against the government, basically alleging that the government should be responsible for those additional costs. And the board, again, denied that claim and found that because the actions were due to the third-party actions of these protesters, and the contractor was unable to point to any particular provision of their contract that would shift this duty to the government, that the contractor was unable to recover. So the second thing I want to talk about is a recent decision regarding proof of damages. So I think damages tends to be, at least for lawyers, but perhaps for a lot of folks, it tends to be a more amorphous area where it can be difficult to come up with, well, what are my damages and how am I going to, itemize these? And in this recent case, King Aerospace, the Armed Services Board of Contract Appeals, they had already sustained an appeal on entitlement for King Aerospace. So the board was only considering quantum at this stage. But in looking at the quantum case that the contractor had put on, the board really took the contractor to task and said, you're painting with too broad a brush, that's a quote they used, and essentially took them to task for not doing the diligence or the work of actually identifying and quantifying the discrete impact from the government's actions that had breached the contract. So this case really goes to show that while it might be difficult to quantify your damages, it is important not to just, throw a number out there. You have to have a sum certain, and in addition to that, you have to have a way that you're actually showing causation and, tying your damages to particular itemized lists that the board can understand and actually grant the relief that you're requesting. So with that, I will turn it over to Aaron to talk a little bit more about, well, how do you start your quantum claim from a cost perspective?
Thanks, Emily. Yep, that's a good segue. So from the standpoint of the cost side of things, right? Now our objective is to quantify the REA or the claim amount. And at the end of the day, the goal is to compensate the contractor in a fair way, right? Make them whole in a position where they have the same general profit or loss as if no change had occurred. So that doesn't mean you're not entitled to profit. In some cases, you're not, but in most cases, you are. But the point is, no big windfall, nor should you be at a significant disadvantage as a result of this change. The point is, again, to make you whole. And so, at a high level, you're usually looking at 4 different components of a buildup here. You're looking at what are the costs directly attributed to the change in work, whether added, if added, and then also if there is a combination or we're exclusively talking about a reduction, the costs associated with anything that was eliminated. And of course, if you've already performed it, you're still taking those costs into consideration because they're real costs, but otherwise prospective elimination of work that's to be performed would be a reduction in some way, shape, or form. It doesn't have to be, I've been in situations where we're adding and deleting work at the same time, and there's some or just deleting work entirely, and there's some expectation that it's a sort of proportional dollar for dollar reduction. But of course, there's unabsorbed overhead issues to think about, economies of scale, things that you have to educate and demonstrate are reasons that your quantum is not as high as the government might expect it to be. But so added or deleted work directly attributable to the change, your indirect costs associated with that added or deleted work, profit to the extent it's applicable, and then any contract administration costs. And that's especially when you're in the REA stage and not the claim stage. We talked about how that can include your outside counsel, your consulting costs, and your internal folks that are dealing with the contract administration activities of building up and negotiating your position with the customer. So a good place to start, although not always where I end up, is the table 15-2 in FAR 15. That's, required in certain instances, not always required, but is, again, a good place for a framework of how you would build up your claim or your REA. And so, it talks about some of the things we already talked about, which are what are the different elements of cost that were added or deleted as a result of the change, and that That is materials, services, subcontractors, direct labor, indirect costs, any other costs, facilities, capital cost of money, et cetera. And then it sort of walks through the process of those costs either being deleted, quantifying that, was it already performed, what's the net cost to be deleted, and then of course anything additional, and then they want your support associated with that. So, I mean, really at the end of the day, of course there are times when this is required, and so we'll follow it in that case, but if not, I try to use what I consider the silver platter method, which is basically building up a claim package that is, given the circumstances and the type of work that is added or deleted and the costs associated with that, what is the best way to present this to the reader, the customer, the auditors, that is going to make them understand my story, understand the elements of cost that I'm claiming and the nexus to my claim, and then understand the evidence that supports all of the various costs that I'm saying are incurred and related to the change. So we talked a little bit about how the cost principles, whether it was a cost reimbursable contract or not, that the change has occurred, the cost principles they're in play now. And so we have to be cognizant of FAR 31, and that's, or whatever cost principles are subject to in addition to that, right? DFARS, for example, you may be outside of the FAR and there's still allowability principles you have to adhere to. But in general, we're looking at, is the cost allowable in the form of reasonable, allocable, and then allowable subject to FAR Part 31.2 if you're dealing with the FAR 31 cost principles. In addition to that, you've got your contract-specific terms that you have to be cognizant of and might have additional requirements in them, and then CAS, if appropriate, if you're CAS covered, and if you're not, then GAAP. And so, that all needs to be considered and included in your claim. It's definitely one of the reasons the claim can get thrown back or, poke holes in it if you're not cognizant of that going into the process. And at the end of the day, again, the goal is this equitable adjustment, right? It's not a windfall, it's not a big loss, it's equitable. And this always reminds me of the fairness principle when you're thinking about termination settlement proposals. It's, the goal is to be made whole and to be fair in this, not to hurt or necessarily, give a boon to the contractor or the government, vice versa. So I sometimes use this and the fairness principle in FAR Part 49 if I'm working up a claim and negotiating with auditors or customers, COs, ACOs, and I've had limited success with the auditors, although it plays occasionally, more success with the COs or the TCOs, and, at the end of the day, it's their decision. So, negotiating the fact that despite XYZ, this is actually not fair, and here's why, and I can demonstrate that. So, it's a little bit of a stretch sometimes, but it's something that can be used and has relevance or a basis in the regulations. And so, certainly you need to be thinking about your consistent accounting practices, and if you're deviating with that, how you're deviating from that. So, we're building things up by cost element to the extent we can. That's definitely the goal. Occasionally actual is always preferred over estimates. We'll talk a little bit about that, but you're using one or the other and grounding your basis in as much fact as you can. You're trying to adhere to your policies. Otherwise, that's an area of risk. And also, if you're CAS covered, your CASB disclosure statement. And, with respect to COVID-19, that's definitely something to be careful of because, we're dealing with, let's take the paid leave ready state example again. I mean, we're dealing with something that's basically unprecedented, and so you want to be cognizant of running afoul of your disclosure statement, but are you going to be able to treat those types of costs in different circumstances than the otherwise like circumstances you've laid out in your disclosure statement? So the DPC guidance, they spoke to this some, they gave an example, and I'm not advocating for using this method, but it is a method that might make sense given the circumstances of your particular contract and change, where they talk about, taking the paid leave and the impacts from COVID-19 and creating an ODC cost category of its own for allocation of some sort. So the idea being it's a new cost category, it's not a cost accounting practice change, and so wouldn't run afoul of your disclosure statement. or issues of that sort. I mean, they say more guidance is coming on that, so we'll see. And again, I think there are reasons that that method doesn't make sense in particular circumstances, and direct charging would be better, or some hybrid, but that is an example of an option that has been spoken to in the guidance and is, relevant, of course, if you have a disclosure statement already published. All right, next close.
Into our next polling question. So this one is, does your company currently have any outstanding claims or REAs against the government? Just to see whether people have already started the process of filing REAs or claims, or maybe people are going to wait until the country gets back to normal to do that. But why don't we go ahead and take 30 seconds and see where people stand. Interesting. Take a quick look at it. Give it another couple seconds. Right now, the polling data doesn't look like too many people do have any outstanding claims or REAs, which is good.
They're coming.
That's up a little, but it's still pretty heavily no. Still pretty heavily no.
Yeah, we might just need more time for this to all play out. Still pretty early, and everybody kind of dealing with this, I think, navigating the changes and the impacts.
Yeah, I think that's right. I think that most of the companies that I've been talking to, they have their entire portfolio hasn't been decimated. It's just, there's some difficulties if they need to be on site and they can't get there. But a lot of people, I have some companies that have been able to do just about everything remotely, which is, not a bad position to be in right now. Let's go to the poll results. Boom. Wow. Resounding victory for the no's. Oh, that's interesting. Huh. Yeah, I think you're right, Aaron. I think we're going to have to see how this plays out and see what the impacts are. And, there's going to be some accounting at some point where they're going to have to grab money to fund other priorities. And I think that's where you could see a rise in terminations for convenience or deductive changes to contracts, or, perhaps not as much being ordered on a T&M contract as would have been anticipated at the outset.
Yeah, we may have to pose this question at the end of our 4-part series and see how much the percentages have shifted, although I think, they will take even more time for all of this to really play out. So I think more is coming, but not yet.
It'll take time. All right, so we're back to Aaron talking about the impact by cost element that you have lined up here.
That's right. We got a high bar here of no kids or pets or anything interrupting. I hear rumblings in the background of my house, so I got to carry out these 15 minutes strong here. So, yeah, I think, just going back into the buildup of the claim here, thinking through the elements of cost. And this is really a non-exhaustive list of the types of things that you might be, facing or consider as you build up a claim, because you are, or an REA, because you are. It is a little bit of a brainstorm session as you think, as you get involved in this, to make sure you're covering all your bases, all the areas that have been impacted directly or indirectly. So that can certainly be, additional folks, idle, or it can be incurring overtime. It can be performing a task they didn't intend to perform, so extra time, coordination with subs, additional subcontracting costs, loss of efficiency. It can be your materials and your subcontractors, changes in your indirect rates in one way, shape, or form, or your forecasted rates. I think, one thing that we've touched on here that will be important I think for everybody across the board, but even more so for companies that have kind of a hybrid commercial and government portfolio, is recasting your provisional rates and your forward pricing rates as things evolve and you have these equitable adjustments that you want to submit to make sure that you are capturing that change. And even if you don't have an REA that's needed to be submitted, there's strategies around cost recovery if you have, more of a hybrid portfolio, or just your obligation to keep your customer on notice of any material impacts to your indirect rates, inclusive of that limitation of costs and funds clause. And then, of course, profit. So, a little bit more on profit. Generally in the changes clause and the clauses Paul talked about early on, profit is recoverable, not so for suspension of work, government delays, although there's certainly instances where I think both the changes clause and that would apply. So there's some strategy there. And then, you've got, of course, COVID-19 specific impacts or changes, and at least one of them, which we keep coming back to in section 3610, where we talk about the paid leave and keeping folks in that ready state and the costs associated with that. The FAQs have clearly laid out that profit is not a recoverable piece of that. So, in that instance, profit's off the table. And so, this is another reason to talk to your CO in particular, because again, we have that language where you can bill at your full bill rates, which generally include profit, at least for T&M and fixed price contracts. But you need to be backing that out here. Otherwise, to the extent we're talking about REAs and changes where profit is recoverable, there's various ways to approach that. Historical data, how you bid the proposal in the first place, to the extent you disclose profit. Some companies have policies around typical profit margins or target profit margins by contract type or particular area of product or service line. And then of course, DoD often uses the weighted guidelines. And so that's not something a contractor is required to do, but it's something the government looks at. And so oftentimes something, we'll weave into our quantum, which is, hey, if you're looking at it this way, and we are, this is what would be a fair, justifiable profit. And we're kind of helping the government along the lines of the responsibilities they have to carry out anyway in evaluating the claim. So I know we don't have a lot of time, so I'm going to breeze through these a little bit. But, in terms of methodologies, actual costs are always preferred over estimated costs. Probably a given for everybody who's gone through this before. It's always the best evidence if it's real, hard, tangible evidence. Sometimes if your books and records aren't structured to have segregated those costs, showing the actual cost as attributable to the change, which is the ultimate goal here, can be a little bit tricky. Makes it more fun for me. I get to be creative sometimes if that's the case, but at the end of the day, actual costs are certainly the goal. Notwithstanding that, estimated costs are either the only option or a very appropriate option at certain times. And of course, chiefly one of those times is when you're preparing something that's prospective. So, oftentimes your REAs and claims aren't at the end of the whole contract. It's, a change has occurred, and some of it may be in the past, but a lot of it is going forward, and the government is able to negotiate, the cost increase associated with that prospective change, and the contractor is willing to take on that risk. And so then you are dealing with estimates, and sometimes you're dealing with estimates anyway when you're not able to segregate out specific costs incurred with a particular discrete activity or cost element. So, at that point in time, there's a lot of ways to do estimates, and I won't get into all of them, but you're relying on hopefully some real data, historical data, cost rates, things like that, or you're looking at different studies, performing interviews. There was a claim recently we did where almost, I'd say 75% of the costs were just internal time spent, but it was a fixed price commercial services contract where a lot of the folks, especially the corporate G&A folks, they weren't recording their time to these specific activities. Of course, we would have told them to had we been involved in the beginning, but after the fact, non-starter. And so what we did was go through and develop a fairly rigorous survey and interview process to try to justify our best estimate of where the time was spent associated with the change and outside of the change, and build that up. There's the measured mile approach. There's analogous cost elements or events you can use to say this is very similar. There's lots of lots of things you can use to help support your estimate as at least reasonable. In terms of what, regardless of estimate or actual cost, and usually it's perhaps some combination, there's a few ways to price the claim. Overall, we usually talk about things in terms of total cost, modified cost, and discrete cost buildup. The total cost method is by far the court's least favorite. Try not to use it.
Yeah.
You're basically it's basically I don't know how to segregate costs associated with the change. And so I'm not accounting for the fact that some of the overrun might be my fault or my bid was unrealistic in the first place. And so it's just, you have to show, of course, some factors that make this even usable in the first place, which is the contractor's bid was realistic in the first place. You don't have the ability to show actual costs in any discrete circumstances. You don't have responsibility for any added costs, and that those costs are otherwise reasonable.
I think the problem is that when courts and when contracting officers see that, they kind of view it as the contractor saying, something went wrong, please pay me. They don't really have like the tick and tie that you need to create the willingness by the government to reimburse you for your costs. It's just sort of, then something bad happened.
Right, and there's just too many ways for the auditors, the customer, and the attorneys involved on the other side to throw shade on what you put forth using that method. The modified cost method goes a step further and does adjust for some things, acknowledging that the contractor had some responsibility in certain areas, but otherwise still looking at kind of a largely total cost method. And then we've got the discrete buildup, which is really more of what we've been talking about, what I'm always trying to do in developing the quantum, and that's directly identifying increased cost by cost element, nexus to the claim, as precise as possible, and then supporting that with backup, for each area of cost. Those artifacts are key. This is just a little chart that depicts that. And then a little bit about the audit process. I mean, for the most part, of course, it depends on the size of the claim, the circumstances of the claim. But in general, you need to be prepared for your REA or your claim or your termination, what have you, to be audited. Oftentimes that occurs prior to any negotiations starting. Sometimes it's a little bit later. If you're dealing with a contract where there's been multiple changes, you've got a post-completion audit sometimes as part of a contract closeout. And so it's just something that regardless of the situation, you need to be prepared to endure. And that means what we've been talking about, which is making sure that your documentation is very supportable, airtight to the extent, you have the ability to do that and to know where your weaknesses are and have an answer ready if they come at you with that, and to make sure you have that narrative and that story that walks the recipient through what you're claiming and why.
And next,
this is our last polling.
The last polling question we have, or next last polling question we have, is what is the likelihood that a COVID-19 related claim or REA will be subject to audit? And I think the point we're trying to get at is, given the amount of money that's flowing out and the scrutiny that it's going to be subjected to, our contractors are going to be at risk of having more audits and which potentially raises a whole host of claims. So why don't we just go ahead and take a look at that, and then we'll get into the end. Yeah, this is Aaron. This is coming in. I think how all of us think it's going to come in. Like the the scrutiny is about 44%, likely is 33%. Some people have no opinion. Unlikely is only like 10%. So that's about what I would what I'd expect. What I'd expect. So I'm gonna go ahead and post that. So there's the results of a poll. And then I think that brings us to the next section, which is that we'll wrap up with best practices for claim package. I think that you know, the one thing that we've talked about is, and I think that all of us have touched upon, that documentation is key. The better and more thorough documentation you have, the more likely you're able to get your claim wrapped up quickly. So I think, you know, that's important. The more contemporaneous documents you have, the better off you're going to be. And the more consistent you are in your story, because you are telling a narrative to the government, you know, that when you put this package in, you want this to be the same story you're going to tell throughout the process, because you don't want to get to the appeal stage and have to go back and backtrack on the story that you told initially, because you're not going to get, you know, like I said, the settlement's going to be low. I know. What do you think, Emily and Aaron?
Yeah, I mean, I think this is, you know, the communication aspect of this is paramount. I think we touched on that. I mean, it's as proactive as you can be, as early as you can be. You know, this is new for everybody on all sides of the table. And so talking through the changes that you see on a particular contract to your customer and working through, you know, the recoverability of that in their eyes, how you treat that on your invoices, you know, even to the formatting, like we talked about earlier. Some of the feedback I've been getting is around formatting. And then just going back to the documentation, those conversations, I mean, if you can get their responses in writing, all the better. And if you can't, that's, you know, that's meeting minutes, that's notes that become those contemporaneous documents later.
Yeah, and you can also use emails to do things and like follow up with government people, send emails to yourself, you know, about things that have happened as a lawyer. You know, if you just put it in writing, you know, and it's contemporaneous with the event, like, you know, we can work with it. But it's where you're trying to recreate things that happened, you know, 3 or 4 years ago that becomes problematic. I think the other problem you have is that, you know, when these situations arise, people aren't always circumspect in their writing, and you know, you need to teach your employees to like just get the facts down. I don't need a bunch of adjectives. I don't need a bunch of adverbs. I just need the facts. You know. The next slide we have is
I would add.
Oh, go ahead, Emily, I'm sorry.
One thing I would add is I think it's good to have a strategy up front, especially if you think that you're going to get pushback from your government customer on a request for a change order or an REA, that you kind of start thinking up front, you know, about timing and strategy for when you're going to file your REA versus the claim, and also understanding the different deadlines that you're going to have for those, as well as for appeals that you might have to one of the boards of contract appeals or to the court.
That's a good point. The next slide kind of shows the sources of supporting documentation. These are sort of the ore that you're going to use in your claim that you ought to be mining. And the last couple slides talk about maximizing recovery best practices. You know, I think we've all talked about being proactive, starting early, documentation, know your contract so that you know when a change has occurred, so it may be a compensable event. You know, I think Aaron has done a good job of like talking about the ways that you quantify your claim, because at the end of the day, that's what you want. I mean, you want your win to be money. You don't want it to be able just to say to the government, hey, I beat you. You know, that's really not much of a victory. I don't know, Aaron, Emily, do you have any other thoughts on sort of best practices and things of that nature? So we can wrap her up.
Yeah, I think we've got the materials there, and I think we kind of hit on it. If we're able to, we can get to that last polling question, which we were going to hopefully publish at the end here as a takeaway for everybody. But,
the last polling question. Yep. So the last polling question is: What is your biggest challenge? What is the biggest challenge your company faces in the government contracting space of the COVID-19 pandemic? And then I think our plan is to, you know, non-attribution, obviously, but just to publish sort of what the challenges that people are seeing over the horizon. If people want to take a second to fill that out?
Yeah,
Excellent.
totally anonymous, and we can do some aggregation of the responses here and send it out along with the slides.
Yeah, as you're filling that out, we have gotten a fair amount of questions. I'm sorry we didn't leave enough time to answer questions, but we will take a look at the questions and then follow up with you individually to the extent that we can. So I'll go to the last slide. Thank you again for joining us this afternoon. I'm sorry we ran over along a little. Hopefully you found the program helpful, and hopefully we'll see you at the upcoming program regarding termination settlement proposals. I don't know, Emily or Aaron, do you want to add anything?
No, I appreciate everyone's time. It's great to do it.
Thank you, everyone. Stay safe and healthy.
Be well, everybody. Thank you.
So long.